One morning I received a piece of mail from a law firm thinking it was addressed to me. I open up the mail and what do I see? I see a letter from the defense attorney in this medical malpractice case addressed to someone else. And I'm wondering, okay, why am I receiving this piece of mail that now talks about his expert opinion in detail? It talks about their strategy. It talks about what their intentions are about settlement. And I'm wondering, why is this letter being sent to me? And I'm looking on this letter to see if I have been copied on it, and I don't see my name anywhere. But yet on the outside of the envelope clearly has my name, and it's addressed to me and my law firm. And I'm wondering, why is this defense attorney sending this to me? And you know what conclusion I reached? Want to know the answer? Come join me for a walk around the marina as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The conclusion I reached was that this letter was sent to me in error. Somebody in this defense attorney's office made a huge mistake, significant mistake, groundbreaking mistake. I should say earth-shattering mistake for this defense lawyer. Now, why do I say that? Because what this defense lawyer did was he revealed to me everything that he did not want me to know about. This attorney and his letter revealed to me who his medical expert was. This attorney revealed to me what his expert actually thought and where the strong points were for the defense and where their weak points were as well. Then, this attorney revealed to me their exact strategy and recommendations for going forward with this case. Now, he revealed all this to me as well as all of the weaknesses in this case. Now, is that great for me? Absolutely, it's great for me. Can I use this letter in any fashion whatsoever during the course of this lawsuit? The answer is maybe yes, and then again, maybe no. Now, why do I say that? First of all, this clearly was a mistake. This letter was clearly not meant for me. This letter was meant for a claims examiner, and now was a discussion between the defense lawyer and the claims examiner about their strategy, about their strengths, about their weaknesses, about what their expert had to say. Now, what obligation do I have as an attorney? What ethical obligation do I have once I receive something that clearly should never have been sent to me? In New York, I have an ethical obligation. You might be thinking that I'm jumping up and down for joy now that I have learned all the details, the secrets behind the defense's strategy. Well, I might be doing that up here, but I'm not doing it outwards. You know why? Because that could happen to me. It could happen to another attorney. And it clearly is a mistake that should not have happened. And it's going to be an embarrassing mistake for the defense attorney, and I'll tell you why in a moment. So now, my obligation as an attorney is to take that document and send it back to the defense lawyer with a little note saying, hey, I believe this was not meant for me. I'm returning it to you. Have a nice day. That's it. And now, when I send it back, what do you think is going to happen? The defense attorney will know that he sent it out by mistake. Someone in his office mistakenly mailed that to me. He will know that all of his defense strategies have been revealed. He will know that his medical expert is now compromised. He will know that everything he planned on doing during the course of this lawsuit is now exposed and in the open. He will know that he is now vulnerable. So now, how can I really use that information to our advantage? I'll tell you how. I can't use it at trial. That's number one. Because this is personal communications between the defense lawyer and his client, and now I can't use that direct information. But what I can do is I can use the strategies to negotiate. I can make them recognize and understand that they acknowledge these significant weaknesses as part of their case. I can get them to recognize that this expert may not be as qualified as they believe him to be. I can now show to the defense that their entire strategy, their mindset, their thinking is not the way it should be and really is not what a jury is going to see. And by doing that, now I gain the upper hand in settlement discussions. Now, it's not as if I'm holding it over their head. That's already been revealed. The fact is, they are now at a significant disadvantage because their strategies have been revealed. What happens, though, if the defense turns around and says, doesn't matter, I don't care, we're still going to trial. We're not going to negotiate. We still think this case is defensible. Is that going to help me? The answer is, even though this attorney's letter has now revealed all those details, it's not going to help me directly. It's not going to prevent them from going to trial. And now at trial, I can still use that information with my expert. I can now use some of that information to cross-examine their expert, but I could not turn around and say, hey, Dr. Jones, isn't it true that you spoke to this defense lawyer on this date and you told them that they didn't have a basis to defend this case? Now, I can use some of that information to cross-examine their medical expert, and that is true. But to use it in other ways, I can't take out the letter and say, isn't this the letter that was involved in that conversation? No, because that is not evidence that I could get into court. That would not be admissible evidence. That would be most likely privileged communication between the attorney and his client. And no matter how much I would like to tell the jury about the details of that, I can't do it directly. So instead, I have to use certain strategies to expose some of their misgivings, to expose their weaknesses when I go ahead and cross-examine the defense expert, when I go ahead and question some of their witnesses. So why do I share this interesting story with you? I share it with you just to highlight something that never should have happened. When I received this letter from the defense attorney saying, hey, thought you should know this information, when in fact, it never should have been sent to me. You know, I realize you're watching this video because you wanted to see the nice scenery. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.